This is an introduction to the practical application of the Minnesota Protocol. And this will be useful for anyone wishing to use the Minnesota Protocol in their work, whether they be judges, lawyers, prosecutors, victims groups, civil society, or journalists. Now, the Minnesota Protocol serves a number of purposes. First, it has a legal purpose. It forms part of the international law and standards that apply to the investigation of unlawful death and enforced disappearance. But perhaps more significantly, it serves several important practical purposes. First, it's a practical guide for investigators conducting investigations. And it's a practical guide for forensic pathologists and other experts conducting, for example, autopsies, exhuming mass graves, or examining skeletal remains. But it's also an important tool for anyone evaluating these processes. For example, judges, lawyers, prosecutors who do that in a formal setting, and also victims groups, civil society, and journalists. I'm often asked whether or not the Minnesota Protocol is a legal treaty or a legal textbook. But I always emphasize that no, above all else, it's a practical tool. It's something that investigators can put in their backpack and take into the field alongside their own national standards and use as a reference guide when conducting an investigation. And we already know that different investigation teams around the world are using or have used the Minnesota Protocol in this way. Some of the states that I have personally met with and conducted trainings of the Minnesota Protocol with report that they are now using it in their work. And we also know that the Minnesota Protocol has been used in Rwanda, in Bosnia, East Timor, Guatemala, and Peru. So let's start by talking about how it is of practical use to investigators, who are the most obvious users of the Minnesota Protocol. The Minnesota Protocol contains a detailed guide for investigators conducting an investigation. Part 2 describes the relevant international legal framework. Part 3 describes the applicable professional ethics. Part 4 sets out the conduct of an investigation, and it contains several important subparagraphs: general principles, the investigation process, interviews and witness protection, recovery of human remains, identification of dead bodies, types of evidence and sampling, autopsy, and the analysis of skeletal remains. And some of the most important guidance is contained in Chapter 5, which are the detailed guidelines, broken into 5 parts. The first is on crime scene investigation, then interviews, the excavation of graves, autopsy, and the 5th is detailed guidelines on the analysis of skeletal remains. The annexes to the Minnesota Protocol, found in Chapter 7, also have enormous practical value. They contain a number of different sketches and diagrams that people may wish to use in an investigation, and also different forms and charts. And all of this information will be of practical assistance to an investigation team. As I mentioned, it's also going to be useful for experts who are conducting certain processes as part of an investigation. For example, forensic pathologists who might be conducting autopsies, or forensic anthropologists who might be analysing skeletal remains. They will be able to use the Minnesota Protocol to guide their work in accordance with international law and standards. The Minnesota Protocol is also an important practical guide for anyone evaluating these processes, whether or not in a formal setting like judges, lawyers, and prosecutors, or an informal setting such as victims groups, civil society, and journalists. Let's begin by talking about prosecutors. And I here refer also to the ICJ's Practitioner's Guide number 14 on the investigation and prosecution of potentially unlawful death, which sets out some practical ways in which the Minnesota Protocol can be used by prosecutors and lawyers. Now, a prosecutor who's received a case file from an investigator to take it to court will find the Minnesota Protocol helpful in evaluating the case file. When receiving a case file, prosecutors have a number of roles. One of them is to review the case file to determine whether or not the investigation has been sufficient, whether there's enough evidence to take the case to trial, or whether further investigative steps need to be carried out. Maybe certain investigative steps need to be redone. Perhaps a witness needs to be re-interviewed. And it would be difficult for a prosecutor to advise an investigator any deficiencies in the investigation or certain steps that still need to be taken without a document like the Minnesota Protocol to set out in detail the investigation process. Another important way prosecutors may use it is as part of their critical role in upholding human rights. Prosecutors, when reviewing a case file, should also be analysing it to ensure that there is no evidence of any rights violations, and if there are, to make sure that there are sufficient remedies and reparations in place. For example, it may be that when a prosecutor reviews a case file, he or she may determine that some of the evidence may have been obtained by torture or ill treatment. And in that case, it may be that the prosecutor should launch an investigation if he thinks the evidence is credible enough, and also certainly should not use the evidence obtained by torture or ill treatment in the criminal trial. So the prosecutor will be using the Minnesota Protocol in a number of different ways, evaluating the case file and all the different investigative steps that took place, and also to ensure that the different rights that the accused person and other persons have during an investigation have been upheld, and if they haven't been, to put in place appropriate steps. Lawyers will also find the Minnesota Protocol of practical value. Lawyers in a criminal trial acting for the defense will find it helpful in evaluating and challenging the prosecution case. This will be important both pre-trial and during the trial. Pre-trial, in some inquisitorial systems, where the defense is unable to carry out its own investigations, the defense may wish to use the Minnesota Protocol as a guide for what investigative steps it should request be carried out. On the other hand, in an adversarial system, it may help defense lawyers know what the shape of an investigation should look like, what should be recorded, and what should be found on the police file. And this will help them request further and better disclosure in advance of the trial. At trial itself, the Minnesota Protocol will be helpful for defense lawyers in challenging the prosecution case, maybe, for example, cross-examining prosecution witnesses. And I was called on to do this early in my career, where our client had been arrested for possession of drugs. And it became important for his defense as to which rooms the drugs and drugs paraphernalia were found in the flat he was sharing with a number of different people. But when we reviewed the photographs on the police file, we saw that rather than things being photographed in situ, as is required by international law and standards, they had in fact been moved around, such that it was no longer really possible to determine in which room different drug paraphernalia was found. And we used this as a way of challenging the police during cross-examination and making a submission to the jury at the end of the trial that there was a reasonable doubt as to our client's guilt. Another example where you might use the Minnesota Protocol to challenge the defense case might be with respect to a forensic pathologist. Let's say an autopsy was carried out, but you can see from the case file as a defense lawyer that the process had not been photographed or had not been videoed. So you might want to use the Minnesota Protocol, paragraphs 253 to 255, to cross-examine the forensic pathologist. And here's an example of how you might cross-examine them using the Minnesota Protocol. You'll have the protocol sitting there in front of you, and you might ask questions like this. You are a forensic pathologist with over 20 years of experience, aren't you? Yes. And you are aware that autopsies should be carried out to a certain standard, aren't you? Yes. One such standard is that they should be adequately documented. Is that correct? Yes. And that is so that the integrity of the findings of the autopsy may be examined, including in a criminal trial such as this one. That's correct, isn't it? Yes. You should record the date, start and finishing times, shouldn't you? Yes. You should record the names of the pathologist and anyone else in the room who helped with the autopsy, shouldn't you? Yes. Adequate photographs should be taken, shouldn't they? Yes. And adequate videos should be taken as well, shouldn't they? Yes. And in fact, that's crucial, isn't it? for the thorough documentation of an autopsy. Isn't that true? Yes. And this line of questioning would place these standards on the record during the trial, enabling the defense to make submissions at the end of the trial that raises a reasonable doubt about the guilt of their client. Now, lawyers may also use the Minnesota Protocol in strategic litigation when seeking to set out the relevant international law and standards that apply to the investigation of unlawful death and enforced disappearance in pleadings such as habeas corpus applications, submissions, or different appeal briefs. Lastly, I'd like to talk about how judges and civil society and victims groups and journalists may use the Minnesota Protocol in a practical sense. Judges may use it in their work, perhaps when, for example, setting out the relevant international law and standards when considering or presiding over an unlawful death case or an enforced disappearance case. And we've already seen some judges at the appellate level use the Minnesota Protocol in that way, refer to it as part of the body of international law and standards in some jurisdictions, including in India. Now, civil society, victims groups, and journalists, they play a really important role in evaluating and running alongside the conduct of an investigation. For example, when a suspected unlawful death or an enforced disappearance take place, it's often civil society who wish to push for an investigation that meets international law and standards. And the Minnesota Protocol will provide these groups with sufficient information about the conduct of an investigation to know when it should commence and what it should look like and what steps should be taken for it to meet international law and standards. They will see, for example, not only that investigations need to be prompt, effective and thorough, independent and impartial and transparent, but also all the different practical steps that should be taken, from the way witnesses should be interviewed, the way autopsies should be conducted, the way in which investigation teams should be organised. And all of this knowledge and information will give them a lot of power in their advocacy, whether it's direct advocacy with the police, advocacy with the government, or advocacy at the international level, where they might be calling on third states to bring pressure to bear for an investigation to take place that meets international law and standards. Lastly, it may also help civil society to conduct their own documentation. Now, the Minnesota Protocol really contains standards that meet a criminal trial standard, which isn't always necessary for the objectives of civil society who might wish to document what's happened in an enforced disappearance or extrajudicial killings case. But the Minnesota Protocol might certainly encourage them to, perhaps as part of their own documentation, seek some external assistance, maybe of an independent expert to come and review some of the information that they have possession of. And it may also provide them with some best practices that also apply to human rights documentation. For example, the section on the best way of interviewing witnesses and best practices in that regard. Thank you.